All right, good afternoon, everybody. I'm Greg Kiley, 2020 president of CCI AOR and CCI MLS. We just are letting everyone filter in right now. We're already over 60 people, so we'll just let that number start to level off. But we wanted to pull this together on short notice today to deal with the latest updates that the governor provided us yesterday, and in particular on how they impact our vacation rental / short-term rental economy down here on the Cape and the islands. So thank you, Ryan, for pulling this together, and Catherine Taylor, who's the Associate Counsel at Massachusetts Association of Realtors. We've all been talking about this since late afternoon yesterday, and I know we've now had some time to help advise everybody on it. So know that we'll do some Q&A. So there's a Q&A button on the bottom of your screen. I will compile the trending questions, and then as we get to the end of this conversation, we'll make sure that we answer everything that we have the ability to answer. And like we said on Monday, this is going to change minute by minute, and we just are going to make the commitment to get in front of everyone as quickly as we can with the best information. So that's it from me. Off to Ryan and Catherine right now, and thank you guys.
Thanks, Greg. So I just want to set the table because there's a whole host of nuanced questions about your leases and things that Catherine's going to get into, but just want a quick overview of what the governor's order was yesterday. Essentially what his order was what our guidance as an association was to our members starting last week anyways, was just not do short-term rentals right now. I'll get more into his orders, but the reason why we have been saying that to you guys is because we do want to save the summer. And, we need to get healthy as a community. We need to make sure that the community and this kind of thing is gone by the summer at that point. Catherine, can you hear me as well? I just want to make sure because it seems like we're getting some feedback that may be an unstable connection.
I can hear you. You're chopping in and out a little bit, but I can hear you overall.
Okay. All right. So hopefully that works. So essentially what the governor's order was yesterday was that you cannot do a short-term rental between now and May 4th when the stay-at-home order is in effect till at this point, which means that no one can take occupancy in a short-term rental even if they had a already existing leasing contract. This does not mean that you cannot take bookings for past May 4th to that start past May 4th. And so we just wanted to clarify that from the start. We want to run through some of the questions we already have from people and let Catherine kind of go over them. Catherine, from the governor's order, anything I haven't mentioned that's really important to point out to start with?
No, I think you covered order as far as, you're not allowed to take even if you have a contract, that contract isn't going to apply now through May 4th. And as you said, that date is certainly a moving target. Hopefully it doesn't get extended too much beyond that, but we never know.
So let's start there. What if you had a contract that was starting before May 4th? What should you be doing?
So if you have a contract that was supposed to start for before May 4th, so between today and May 4th, and that contract was for less than 31 days, so it's well within that short-term rental time frame, you are unable to provide occupancy to that individual per the governor's order. As far as the follow-up question is, well, I've already taken a deposit. What do I do with the money that I have? Am I owed any additional monies? What happens with all of that? And basically, you're going to look to the terms of your contract if it has a cancellation provision that specifically applies, which is typically a force majeure. I think many of these contracts don't have that language in it, so then we're going to be looking towards the common law provisions of impossibility, which means you can't perform due to circumstances beyond your control, which certainly this pandemic was not anticipated, and it's beyond all of our control. So that excuses performance under the contract, which means that there's no money due under the terms of that contract. If you have taken a deposit from a client, you're going to be refunding those monies to that individual as you're unable to perform, as are they.
So the question is, in Massachusetts is one of the few states that allows you to distribute the money to owners before occupancy occurs.
Mm-hmm.
You got to get the money back from your owner. What if your owner doesn't give it back to you? How does that all work?
Right. I mean, that's sort of the $1 million question here, right? Is that we're a little bit unique in that regard, that we're allowed to distribute those funds prior to occupancy. And, people are using those to pay their agents, their fees, to pay the homeowners are using it to pay their mortgage. They might not have that money sitting in an escrow account that they're able to just turn around and refund it. It's all about communication right now between brokers and their homeowners that are looking to rent, as well as with prospective renters, and see if you can figure out a solution, and just open those lines of communication and figure out what's going to work for everybody, whether it's refunded over a period of time, whether it's credited towards a future stay, maybe next year. There are options that you can work at. If you're unable to come to a solution, unfortunately, there's probably going to be a number of situations that end up going to the courts for resolution, but we're hopeful that most people will be able to work out something that is mutually agreeable between everybody and stay out of the courts.
All right, and then one thing to touch on, order that you can do a short-term rental at right now. And I'm just going to run through those real quick. Housing for healthcare workers, first responders, and essential COVID-19 essential workers. Is that the COVID-19 essential workers pretty much anything that falls under essential business for the under the governor's order, or is that more of a definition?
Yeah, I think it's going to be that same list of individuals that apply under that. If they're in need of housing, you're able to rent to them on a short-term basis to do that. I think it also includes individuals who have been displaced from a long-term care facility as a result of this. They need somewhere to rehab or receive, specialized care. You could do that.
That's another one. I was going to run through all of them. Another is housing for out-of-state workers engaged in transportation of materials, logistics, construction, associated delivery of health-related services, housing for vulnerable populations, housing for residents who are self-isolating or self-quarantining, or the families or roommates of individuals who are self-isolating or self-quarantining, as long as it's only necessary to complete that isolation or quarantine. Housing for the long-term medical care, as you talked about. And then also housing by extenuating circumstances such as fire or casualty. So if my house burned down right now, I could go do a short-term rental or something like that. Or flight cancellations, border closures, like if I can't travel back to where I'm supposed to go.
Right, exactly. So it's really, fairly limited circumstances, but it's not totally shut down, but it's very, very much restricted.
On that note too, I want to point out, because this was very specific in the governor's order, we're only talking about short-term rentals as defined by 31 stays of 31 days or less. I'm getting a lot of questions about booking 90-day, 120-day stays, 180-day stays right now, and those aren't covered in this order.
Correct.
Now, however, and I'm talking to your counterpart, Johnny, yesterday, we're paying attention to local boards of health, because they may be issuing different directives that go beyond this as well, as far as out-of-towners coming and staying in town.
Correct. So it's important to, stay on top of not only the state guidelines, but as well as, what the locals are doing.
So what happens then if I start business as usual for my normal June, July, August season, and I'm continuing to take bookings now, What happens if the stay-at-home order is extended, and what should I be telling clients that are booking now in case the stay-at-home order is extended?
Right. So any new bookings that you're taking now for later in the summer past that May 4th date, again, I think communication is going to be key, and letting them know that we have this order in place through May 4th currently, but that's subject to change. And you want to make sure that that's captured in the language of your contract, in some sort of an addendum or a force majeure clause that's going to excuse performance under the contract in the event that due to this pandemic that you're unable to provide occupancy. Common law doctrine of impossibility would not apply under those circumstances because it's foreseeable at this point that you wouldn't be able to deliver the premises. That there's a real possibility that the stay-at-home advisory is going to be extended. So you need specific language in your contract. You can't rely on those common law provisions because you're not going to have protection otherwise. I will say that MAR is looking at developing language for you. I can't tell you what the date will be that it will be released, but we are definitely working on it and hope to get it to you as soon as possible.
Like kind of addendum for them to provide for new leases going forward.
Right, exactly. It specifically says, if as a result of, COVID-19 or the pandemic or however you want to phrase it, there's travel restrictions or there's restrictions on short-term rental leases in Massachusetts, the parties are going to be excused from performance, which again means any money would likely be refunded unless that phrase says otherwise. They could include, they could include a cancellation provision, and it would be based on what the language of the contract was rather than those common law principles.
All right, and then beyond the governor's order, because this question was coming up a lot anyways, outside of the governor's order, is I'm having a lot of people cancel maybe for the summer now. What am I supposed to do on my cancellation policy for the summer if the governor's order is not in effect for the summer, but they still don't want to come because they don't want to travel, all that kinds of stuff. You address the MAR lease versus other things and other factors you should be considering.
Yeah, absolutely. So I can only speak to the language that we have in the MAR short-term rental lease, which I can read the language. You give me 1 second and I'll open it up in front of me so I can tell you all exactly what it says. In the MAR lease, it says, on the date the lease begins, if despite reasonable efforts the landlord is unable to deliver full possession of the premises on the date the lease begins, the landlord shall not be liable to the tenant for any loss or damage, nor shall this lease be void or voidable, but the rent for the lease term shall be proportionately reduced, and the tenant shall not be liable for any rent until possession is delivered. So that's where I was talking earlier about that prorated amount. So let's say you have a lease that's supposed to begin on May 1st and go through May 10th. And you can't deliver the premises until May 5th because the current order is in effect till May 4th. Obviously, this is in hypotheticals and the order isn't extended. You would then prorate that rent back to the tenant under the MAR lease. If you have somebody who's looking to cancel a lease that you already have entered into for, let's say, June, July, August, where there is no order extended that says that they're unable to deliver the premises, you're going to look to the terms of your contract and what cancellation clause you may or may not have in your contract. And you have a legally enforceable contract at this point with regard to that. So it's really, again, that communication, you as the broker need to be talking to your homeowner to figure out a solution, based on what the language of the contract you use says.
And I'm getting a lot of questions from people in this vein of, oh, what's everyone else in the industry doing? Are we going to refund the money? Are we not? What are owners doing? Can you talk about how careful they need to be about creating this, like working among competitive brokerages to create the same cancellation policy?
Yeah, absolutely. I mean, any cancellation policies or policies you develop pertaining to refunds at this time should be developed in consultation with your clients, not with other brokerages. In doing so could certainly be a violation of the antitrust provisions. So you want to make sure that you're not working in concert with your competitors and coming up with an industry-wide policy, so to speak, with regard to cancellations and refunds. It should be done with your clients and what's in their best interest.
All right. Greg, questions we have coming in?
Yeah. So I think most of them have been addressed pretty well. The one I keep on seeing is, going back to the essential need workers and the fact that they're still going to need housing. What are our recommendations or best practices for either verifying or keeping records on the fact that whoever occupies is in fact entitled to occupy under the state regulations and restrictions?
Yeah, I mean, I think it's reasonable to ask for a letter from their employer that says what exactly their role is, that defines them as an essential employee, and then you should keep a copy of that in your files to protect you, to make sure that you're if it were to come back to you, if they weren't actually an essential employee that's able to stay under here, that you can say, well, they provided me this documentation, so you need to make sure that you're checking those boxes to avoid liability on your behalf.
All right. So the question was, are you saying an owner must refund rental money? I want to be clear. We're saying you must refund the rental money if you are using the MAR lease, or most likely if your lease does not address it under common law, if the stay starts prior to May 4th.
Right.
And if it falls outside the order and they're canceling, that is a case-by-case scenario you should be making with your owners. Right. Can you as a brokerage have a change your cancellation policy for one tenant but not another tenant if they're different owners of properties and stuff like that?
Yeah, I mean, I think it really is going to vary based on the needs of the specific homeowners. You can say, you can have idea as a brokerage, but ultimately they're the client. You're there to serve their interests in this, and make sure that you're listening to what their lawful instruction to you is. So if you say, well, my recommendation is X, Y, and Z, and they say, well, I'd rather do this, as long as it's within the guidelines of whatever contract they do have, as well as the guidelines of the law as it currently stands, you need to be working with them on a case-by-case basis.
And if you had a short-term rental that can't take occupancy because of the stay-at-home order, you also need to refund the money, but also the commissions or any brokerage fees you charge too.
Right. Again, you would look to the contract that you have with the homeowner, if any, and look to see what language is included in there with regard to cancellations, whether you're still entitled to your fee. But in most cases, I would think that fee would also be refunded to the homeowner.
So, Catherine, there are a lot of questions in here about, and I know we've touched on this a little bit, but maybe worth reinforcing, those who are already down here and may not fit under the essential categories, but want to extend because all of these dates are being extended. What our current understanding is on the ability to extend for non-essential occupants.
Right, so the governor's order does specifically address that, and it says extensions are not permitted. So that would definitely be a violation of the order to extend anything at this point.
But what if your extension, and this is hypothetical, but definitely a possibility, say they were down here for 14 or 21 days, and the extension takes you past 31 days?
I'm not sure, honestly. I think that I'm gonna open the governor's order right here, so bear with me half a second. But
because that's a real possibility.
Yeah, I think it is a real possibility, and I don't know off the top of my head, but I'm gonna say, my gut is to say that because he said extensions are not permitted, I would think that would be included in this to not
But if
allow
you
it
wrote
to
a new
extend.
lease for more than 31 days, you should be okay for that person to stay in that property.
Maybe.
Okay.
Yeah, I will look into that, and I'm gonna let's see, I'm just looking at the language right now. Say persons
Yeah, I mean,
occupying.
we can email everyone that signed up for this and give them that answer, because I think that is a key component, especially because if you were down here for 2 or 3 weeks already, and then you're going to end up over 31 days, how that's going to play out.
Yeah, I mean, it says may not extend their originally scheduled stay except for one of the purposes listed in section 1. So unless they fall within one of those categories, I think that's pretty broad language that's included in there to sort of try to cut that scenario that you laid out, cut it off so people aren't doing exactly that. But I don't know. I'll run it by Johnny and Justin, and we can talk more, Ryan, and then we can let people know a more solid answer on that.
Okay. All right.
And just there's again some clarification in here about the difference between 6 weeks and a short-term rental. And just can you re-clarify the difference between the two?
Sure. So anything 31 days or less is a short-term rental. Anything more than 31 days is not a short-term rental and not covered under the governor's order. So you are able to take occupancy on anything more of a lease more than 31 days right now. So I know someone asked about my lease states no commission will be refunded to the owner or tenant under any circumstances. That you really should take that up and talk to that situation with your attorney who wrote that lease then. Right. I mean, so if you had an attorney write your lease, on some of these scenarios, you need to go back to that attorney that wrote the lease, which is why Catherine's only able to really answer about the MAR lease that they write.
Exactly.
So follow up to, some people are asking if they can get some clarification on the common law stuff in writing, kind of an update from MAR so that they can share with owners as they talk to them about that.
I'm also working on writing up an article on that, so stay tuned. That is definitely in the works as well.
Okay. All right.
And then Catherine, you had touched on briefly that, you expected there would probably be some things that eventually might get settled in court if there are disputes here. I mean, I think there are a few people who are obviously going back to Ryan's question earlier about commissions that or fees that have already been paid out to the homeowner and maybe not being able to get those back and needing to refund money that maybe has been used.
Mm-hmm.
And is that something you expect MAR might try to guide us on in the future, or are we going to need to really go back inside our own brokerages and work with our own attorneys to best deal with that?
I mean, I think a lot of this is going to be dealt with on a case-by-case basis. This is turning everybody's world upside down right now. And I think everybody's in the same boat too, that you might not have that money available to refund. That's not necessary. Even if you're legally required to return that money, you have to do that. And it's in everybody's best interest to try to work through a solution that's going to work for everybody. If you have, $2,000 commission that you earned, for example, that you need to return to that homeowner, and you don't have that money, then you need to say, all right, well, here's a proposed solution. Does this work for you? And just try to come up with a solution that does work for everybody.
Another question is about the commission, someone asked, is the federal government including the money to kind of offset some of the owners? No, Airbnb was trying to push that in the COVID economic stimulus bill that the Congress just passed, but did not get any assistance for basically short-term rental owners in that bill. Airbnb and I know VRBO had really launched a big push to try to get that in there, but that was not included. question, if you currently have a guest in place that is rented for 31 days and they want to extend now for 2 additional weeks, I think this kind of still falls under your question before. Like, it's more than 30. If they had rented for more than 31 days and they want to extend, that's all fine. It's that 31 days or less cutoff on the same as the lodging tax. So essentially, if they were being taxed lodging tax before, that kind of scenario, that's that 31-day scenario on the short-term rental thing.
So Ryan, I keep on seeing two very similar questions. So we'll start with hopefully what might be the easier one, and then we'll go to the harder one. Do you know of, or are we able to compile a list of vendors who might be able to provide either cancellation insurance or some sort of insurance policy to our homeowners and to our renters in the case of future extensions of these orders or future delays or restrictions on travel?
That has not come up yet. I can definitely reach out to some of the guys some of the companies in the industry that we're familiar with and ask them and get that answer out in that travel insurance industry. We have quite a few contacts in that industry, and so we will ask them about that and make that available to you guys if there is any such thing. I know from booking flights, most travel insurance ones on the flight, it goes back to kind of Catherine's answer earlier. When I'm seeing flight bookings, it's like, this is now a known issue, and so if it's canceled because of this now, insurance won't cover. Is that kind of, Catherine, kind of how you're saying about common law stuff now that it's kind of a known issue? And you're on mute.
All right, sorry about that. I've got a weird message on my screen that says my speaker is not working, so I guess it's me. So I hope everyone can hear me. But yeah, all right, perfect. So yeah, it's sort of the same principle I would think, as far as the common law. If it's foreseeable and you're booking now, it's probably not going to cover you. But again, if you're getting any of those types of policies, I would make sure that you're reviewing language carefully to make sure it actually provide you the coverage you're hoping it will.
Just to another question, just to reiterate what we said earlier, if someone's already here and they can't extend their lease, they definitely can enter into a new lease of more than 31 days and stay here.
But Ryan, on that, I think there's a question also for those who are already in before this call started. We do not need to kick them out right now if the term of their existing stay agreement still allows them to occupy, correct?
No, you do, right, Catherine?
No, so if they were in the rental before the governor's order went into place, they can stay through the end of their booked stay, even if it goes beyond the 4th, but they can't extend that stay.
If it goes beyond the 4th, they can, because that's outside the order.
Right. But if it goes to the 4th.
If you were to vacate, but the 4th is more than 31 days, so your stay is obviously longer than that. But if you're in a short-term rental right now through April 5th, you can stay in that short-term rental. You just can't extend that rental.
Right.
And Catherine, maybe a legal interpretation, although I know we try to avoid those if we can, if it's not an MAR form, but some people have cancellation clauses. In your opinion, is this a cancellation or is this a different category, and should it be treated, would you advise treating it differently?
So, I mean, again, it really depends on what that specific language of the cancellation clause is. If it says cancellation for whatever reason will not give a refund, then, it's probably pretty all-encompassing and no refund would be due in this situation. If it just says, if you cancel, you'd be refunded whatever percentage or something, I would think this may challenge that. I would always recommend that those clauses be reviewed with an attorney if it's not clear what exactly it's saying. So I think, those attorneys that are drafting those clauses for your brokerages, you should be touching base with them and being like, all right, how does this apply in this situation? And they'll be able to give you guidance on that specific what they
Someone asked about cleaning in this world. That's one thing that's already on my radar, to be reaching out cleaning experts to perhaps do another webinar about best tips on cleaning procedures and what your cleaning staff should be doing during this time. As well. A question about losing income based on returning commissions in here. I think we'll be waiting and would roll that into what we expect. We talked a lot about on our Monday call with Teresa, CEO of Massachusetts Association of Realtors, waiting for state unemployment insurance to kind of roll out their regulations along independent contractors, because that was included in the economic stimulus bill. And so any potential lost income could be potentially grabbed from commissions from you guys, could potentially be claimed in the unemployment insurance as we find out more, hopefully next week, on how that's going to roll out. Right, Catherine?
Right. Yeah, exactly.
And so just, I want to quickly touch two things. A lot of people are saying that Catherine's connection is breaking up a little bit. Catherine, can you just remind people that that MAR has a legal hotline and kind of what the process is if there are specific questions on legal things that brokers might need to get answered?
Yeah, absolutely. So MAR has a legal hotline that is available to authorized users. In order to become authorized, you need to send in the authorization form, which can be found on our website under the legal tab. And then you can just email it over to me or Katie or Zach or anyone really. We'll make sure you're authorized in the system. You can call at any time. We're happy to work through any questions with you. If you're a broker, you can authorize agents within your office to access the legal hotline as well. You can also email us at legalhotline@marealtor.com.
And then one other question that I know that you, Ryan, and I have talked about for the last 3 or 4 days, and just so everyone on the call knows, staff leadership and volunteer leadership. So in that case, Ryan and me, we're on a weekly Monday call with MAR leadership and other state leaders. And we had asked for some updates for the June, July, hopefully robust summer rental season that we're going to have, but maybe a form to protect people who are in doubt right now. They'd like to book for the July, August, and later days, but would love some sort of clause to be in there in case we see these extended. And my understanding is MAR is starting the process of maybe introducing a clause like that.
Yes, we are working on it. We will hopefully have that ready for you as soon as possible.
Perfect.
Okay. And then a great question has come in. What if we don't have the stay in place order after May 4th, but a tenant has one in their state? Does that affect the cancellation policy and the leases here?
Sure. Yeah, so I think that comes under that question of impossibility. So let's say they live in a state and that state has said there's no travel in or out. So it's impossible for them to perform under their contract. Likely the same principles would apply, as we previously discussed. So first look to terms of the lease. If not, then you're going to look to the common law provisions of impossibility.
Or the same thing, definitely, from like if you have Europe residents coming over for a stay in the summer, and flights to from Europe are still shut down, and
Exactly.
they can't access a visa and get in and all that.
Yep, absolutely.
All right. And then would offering a tenant a week in 2021 rather than a direct refund satisfy legal obligations to provide the refund?
Maybe. I would say that would have to be done through agreement with the tenant. If they are accepting of that as, in lieu of a cash refund, then you can certainly do that. I don't think that you can mandate them to take a credit in that regard.
All right, and those that may have had difficulty hearing, Catherine was pretty solid in ours, so we'll be giving out the audio. We'll be giving out the recorded whole session to you guys, everyone that's registered, so that you can watch it and hear her again. For those that may have had bad connections from their computers, she came through pretty clearly with me. So I think we can handle that from that standpoint on that end.
So Ryan, the only other thing I think a few people asked is what's our plan to continue the updates coming? You know, we had talked on Monday about continuing our Monday morning kind of weekly zoomed in on real estate sessions, but do you expect if there are big wholesale changes like this that we would continue to do pop-up calls like this as needed?
Absolutely. Like we'll continue. The Monday zoomed in on real estates will be more bigger, broader issues. And then also, you know, like SBA funding, because vacation rental companies should be really interested in the SBA funding, especially if your rental agents are on salaried or, you know, payroll. There's some payroll protection stuff in there as well. Also, the unemployment insurance as that rolls out for independent contractors. And so we'll be focused on the bigger issues. Some of these cleaning stuff and some of these things on vacation rental specific, we'll probably do them as one-offs, kind of like this. We'll try to give you more time than the 12-hour notice we kind of gave you for this one. But I wanted to make sure, try to answer your questions so that Catherine and I's 150 emails and calls today were kind of streamlined down to more specific stuff. So I want to thank you guys for taking the time to get on so quickly on this.
Yeah, and I think, you know, the big thing is this is all changing on a regular basis. We all have clients that we have to deal with first and foremost, and it's amazingly wonderful to have Ryan, Marissa, the whole staff at CCI AOR, and then Catherine's on a team of 5 or 6 attorneys who are all working with the governor's office on a regular basis, and then Teresa and her whole team at MAR helping guide us. And then obviously we were joined by Christian and others at NAR on Monday. So none of us are in this alone. It's a huge help, and I think we all appreciate you taking the time today to help us understand this even more.
All right. Thank you guys very much. And like I said, Catherine's legal hotline info is in the chat section for you to take a look at. And we will also distribute this out with with some of those follow-up information that we heard that Catherine said she'd provide too from this. So, and hopefully we'll have a form by early next week at some point about future leases. So.
All right. We'll get it to you as soon as possible.
All right, thank you guys very much, and always reach out to us with any additional questions.
Thanks, everyone.
Thanks, everyone. Stay safe.